And without further delay, we are pleased to have Shauna MacLean and Chelsea LaRose with us this morning. They are safety management consultants from the Yukon Workers' Compensation Health and Safety Board. You may be aware that come September 4th, 2021, all Yukon employers are required to be in compliance with the new Violence and Harassment Prevention Regulation. As such, Shauna and Chelsea are here to give an in-depth review of what this new regulation means for Yukoners, and they will also discuss the tools available to assist employers with compliance. Over to you, Shauna and Chelsea.
Hello, everyone. Thank you, Yukon Human Rights Commission, for including the Yukon Workers' Compensation Health and Safety Board in this conference, and thank you to all the attendees for your interest in preventing violence and harassment in the workplace. My name is Shauna MacLean. I'll be presenting today with my coworker, Chelsea LaRose.
Hello.
At the Yukon Workers' Compensation Health and Safety Board, our primary functions are to promote workplace safety and support injured workers recover and return to work safely. Who the public often sees doing this work is Claimant Services and Occupational Health and Safety. Claimant Services is where compensation claims go. They administer the compensation for workplace injuries and support the safe return to work. OHS, which is where Chelsea and I work, promote workplace safety. Sometimes that's through enforcement activities like inspections and investigations. And sometimes that's through things like what we're doing here today. It's the same organization, just different roles and different authorities. In the interest of protecting the public's information, there are some restrictions on what information can be shared between these areas. And because of this, OHS, if we're looking into a health and safety issue at a workplace, it won't initiate a claim. And if a claim is filed, it doesn't mean that OHS will know about any health and safety problems. So if you need to bring something to one of our attention, you bring it to us. And if you need to bring something to both of our attention, you should be bringing it to both of us. And what we're here to talk about today is Chelsea and I will share with you how violence and harassment are defined under the new Workplace Violence and Harassment Prevention Regulation. We'll talk also about what needs to be done to prevent workplace violence and harassment and how to comply with the new regulations. You'll also learn what you can expect from others at your workplace and some of the supports that are now available through the Yukon Workers' Compensation Health and Safety Board and others that will be released over the next few months. Violence and harassment are not new hazards for workplaces, and it's not a new requirement to protect from violence and harassment hazards. Protection from all hazards in the workplace is a requirement of existing OHS legislation. Specific minimum requirements for preventing violence and harassment are in the newly introduced regulations, though.
Shauna and I will get into the definitions of workplace violence and harassment. But before we do, we need to make it clear that violence and harassment can both cause physical and psychological injuries, and that they are serious workplace hazards. We take it seriously, and we would like you to as well. Occupational health and safety law requires employers to do hazard assessments. A hazard is something that could cause injury or illness to a worker, which can range anywhere from unsafe lifting, unmanaged noise levels, gossiping amongst coworkers, or violence from customers. We know that violence and harassment can both cause physical and psychological injuries. And violence and harassment is committing actual force toward a worker that causes harm or leads a worker to believe that they are likely to be harmed. It is also the attempt to commit violence and threatening to commit violence. And the hazard here is the individual who is perpetrating the violence. Workplace harassment is generally understood as any objectionable comments or behaviors that we know or should know are likely unwelcome. This includes any inappropriate comments or objectionable behavior relating to a worker's gender, sexual orientation, gender identity, or gender expression. These are examples of harassing behaviors that could be physically and psychologically harmful. However, not every incident of unpleasant interactions, disrespectful behaviors, or conflict is necessarily harassment, although it may develop into harassment or violence. I would also like to point out that it is not harassment when managers and supervisors are exercising reasonable managerial authority. It is not workplace harassment when a manager or supervisor gives instructions, changes or doesn't change a worker's job duties, when they determine the schedules and workloads, conduct performance evaluations, take disciplinary actions, or discuss the best way to work with a coworker. However, if a manager uses their authority in a punitive way, that is a separate and distinct violation of the Occupational Health and Safety Act called prohibited reprisals. An example of that would be a supervisor who is regularly giving one staff that they don't like the most undesirable shifts.
So while preventing violence and harassment is not a new requirement, it was identified that specific minimums needed to be set for what was required for preventing violence and harassment. And that's why we wrote and enacted the Workplace Violence and Harassment Regulations. This regulation will come into full force in September of this year. And along with this new regulation, there was an amendment done to Part 1 of our general regulations to include some new definitions, which Chelsea just went over. So what is in the new regulation? The new regulation gives requirements around policy and procedures to prevent violence and harassment, requirements around investigating, and how to prevent domestic violence from impacting a workplace. And Chelsea and I will speak to more of these during this presentation. We also developed a guide to provide more information in a plain language way that includes some templates. From an OHS perspective, there are 3 main roles involved in every workplace: the employer, the supervisor, and the worker. These roles are sometimes blended. What's important to remember is that everyone has a role to play in workplace health and safety, to control the hazards, to report unsafe behaviors, follow policies and procedures, and treat others with civility and respect. For employers, they have the ultimate responsibility of health and safety at their workplaces. Some of the responsibilities that employers have are educating themselves about the hazards, to, if possible, eliminate and otherwise control exposure to those hazards, to protect the physical and psychological health and safety of workers on their work sites, and to develop and implement policies and procedures for workplace violence and harassment prevention, as well as to ensure techniques and procedures are adopted and used to prevent risk of injury. Ensure workers are informed of their rights and responsibilities and duties under the OHS legislation, and to work with joint health and safety committees or health and safety reps if they are applicable at their worksite in fulfilling their responsibilities. Supervisors are a critical part of a healthy health and safety performance at a workplace. They need to provide workers with information about workplace hazards and the information needed to not be affected by those hazards, to provide necessary training to workers to do their jobs safely, to make sure workers are enabled to do their work safely with the equipment and knowledge that would be required, to ensure all the policies and supporting procedures are followed, and to inform an employer of any hazards that are identified. Workers have the lowest level of responsibility for health and safety, But as the day-to-day doers of the work, they have the most direct knowledge of the hazards involved in their work, and their contributions to health and safety management are very important. Workers have the responsibility to report unsafe conditions and behaviors, to follow all the health and safety procedures developed by their employer, and to not create hazards. Even as a bystander, a worker who hears or sees anything that indicates that there's a hazard of violence and harassment at their work site, they should report it to their supervisor, just like any other hazard or incident. Joint Health and Safety Committee is an additional opportunity for workers to support and promote health and safety at their workplace. The Joint Health and Safety Committee is made up of members from the worker and supervisor levels. They provide oversight of the health and safety management system, and they make recommendations for improvements to the employer. The Joint Health and Safety Committee is a requirement for workplaces that have 20 or more employees, and the Workplace Violence and Harassment Prevention Regulations state that the Joint Health and Safety Committee, if there is one, should be involved in the development of workplace violence and harassment prevention policies and procedures. So what's OHS's role? It's to provide information to workplaces, like what we're doing here today, and to administer the OHS Act and regulations, which could look like an OHS officer doing a regular inspection, but asking to see some of the documents referenced in these new regulations. OHS is not in the role to resolve or mediate specific allegations of harassment in the workplace. OHS is also not able to order individual remedies such as monetary compensation to individuals who experience violence and harassment in the workplace, or to interfere with reasonable management practices that do not contravene the OHS Act or regulations. What OHS would do is determine if the required policies and procedures are developed, and are they adequate? They would determine, did the workers receive training on the policies and procedures? And they would endeavor to determine, are they being used? Would they find examples of reporting and investigating?
As Shauna mentioned earlier, employers have the ultimate responsibility of health and safety at their workplaces. So with that, employers must conduct and document hazard assessments to identify what kinds of violence and harassment hazards are in their workplace. Findings must be documented, and from these findings, the policies and procedures are developed. Some hazards that are often overlooked are shift work, working remotely or in isolation, and domestic violence. In regards to domestic violence, we don't expect employers to get involved in a worker's personal life. However, workers need to disclose hazards to their employers, and this includes the threat of domestic violence. The employer needs to have a reporting structure that can capture this confidential information and make arrangements to protect workers from this and all hazards. All employers need a written policy that describes their commitment to creating violence and harassment-free workplaces. Some key statements that need to be in the policy include a statement that violence and harassment is prohibited, that their commitment as an employer to eliminate or minimize the hazard, the worker's right to report, and how they're going to protect the worker's privacy and maintain confidentiality. The policy needs to be developed with workers' input, like the Joint Health and Safety Committee or the Worker Health and Safety Representative. All employers must also have written procedures that describe what everyone in the workplace must do to prevent violence and harassment from causing harm. The written procedure must explain how a worker makes a complaint to or against their employer, and describe the investigation process for both the complainant and the person conducting the investigation. It should also include a process on sharing investigation results, applying corrective actions, and post-incident care for those affected. Procedures are written for workers' use, and they shouldn't be overly complicated. So when you evaluate and modify your procedures, you should ask yourself, do the employees and supervisors understand the procedures? Do they understand what to do? Are the procedures working? If they're not working, make the necessary changes. If workers haven't had to use the procedure, give them a scenario to practice using it and get their feedback.
What's important for workers to know about the workplace violence and harassment prevention regulations are that violence and harassment are hazards and they should be treated as hazards. Trained on the company's policies and procedures and know where to find them for future reference, including things like how to report and what to expect after reporting, as well as that the employer has an obligation to ensure confidentiality of what is reported. To report violence and harassment incident at your workplace, refer to your company procedure. The workplace violence and harassment prevention regulations require a company to have a procedure that provides specifics on how to report, that it must be documented, who to report to, and who the designated person would be if the person alleged to have committed the violence harassment is actually the employer. With reporting, please remember it isn't necessary to do some type of pre-investigation to determine if it warrants being reported for fear of something unnecessary being investigated. That'll get proven out in the investigation. And if it turns out that it was a misunderstanding, there's no harm in clearing the air. Another thing to note is that it may look as though there's been an increase in violence and harassment incidents at your workplace once you start encouraging reporting. But the reality is that that was probably already happening and now you know about it and can do something. Investigations done by an employer are an opportunity for employers to demonstrate their ability and interest to improve health and safety. The new regulation requires a company to have a procedure with specifics like who will do the investigation, how the results of the investigation will be shared with involved persons while maintaining their confidentiality, and how corrective action will be taken and based on the investigation results. And of course, how all of this will be documented. Now, if OHS reviews an employer's investigation and finds that it was not done adequately, an OHS officer can order an investigation to be done by an impartial person. That would be someone with the knowledge, experience, and qualifications to investigate this type of incident. The report then must be given to OHS, and all of this done at the employer's expense. Keep in mind, not all investigations are big. Likely, the sooner something is reported, the less involved the investigation will need to be.
All of our resources can be found on our website at wcb.yk.ca, or you can grab a printed copy of the Workplace Violence and Harassment Prevention Guide at our YWCHSB office located on Strickland Street and 4th Avenue. I'm going to chat some more about the templates and checklists, but I would like to mention something that is not on this list. And that is that we're developing a generic employer PowerPoint presentation for any employer to grab off of our website, make it their own, and use it at their workplace. The checklists provided in the guide are surrounding roles and responsibilities and due diligence to prevent workplace violence and harassment. On this slide here, you'll see a portion of the roles and responsibilities checklist. A toolbox talk is a term used to describe an on-site all-staff health and safety meeting. We have one at YWCHSB every Thursday morning, but we call it a tailgate meeting. Sometimes our president sings happy birthday at our tailgate meetings. Also on our website, there are violence and harassment specific toolbox talks available for downloading and using at your team health and safety meetings. We are currently offering education sessions where you can book to have a speaker from YWCHSB come to your workplace in person or remotely deliver an educational session about workplace violence and harassment prevention. We also offer online sessions every month, and the sessions are free and they're aimed towards everyone. So this is really cool. We've partnered with the University of Fredericton to offer their psychological health and safety courses at a discounted rate of 70% off. At the bottom of the slide, you'll see for more information, visit getstarted.ufred.ca/Yukon. So write that down. If you want any more information about violence and harassment prevention, or if you're looking for any health and safety information in general, you can contact 667-5450 or email us at work.safe@wcb.yk.ca. Shauna and I would like to thank you for giving us your time today, and we are ready to receive your questions. And if your question is about our president singing, I will say that he has fun doing it and it shows.
Hello. My name is Chelsea LaRose. I'm with Occupational Health and Safety. I wanted to introduce, we have Yolaine Pelletier with us today. She's with Claimant Services as a case manager. She's been with us with the Yukon Workers' Compensation Health and Safety Board since 2012, and she assists injured workers in recovery and early safe return to work. She is with us to answer any questions that people may have around claims, because Shauna and myself our expertise is in occupational health and safety. So we have one question. First question is, what would happen if one of the staff is on the OH&S committee and is also the harasser? So in that case, that person on the committee who is also the harasser would not conduct the investigation. And yeah.
So I was wondering, does this mean any kind of inspection investigations? I assume this means with regards to violence and harassment inspections and investigations. The question is, how often do you conduct inspections and investigations? I'm going to assume it means related to violence and harassment. And if that's the case, we generally only at this point do investigations on the topic of violence and harassment when it's been brought to our attention that there is some that might be occurring at a workplace. However, generally, when we introduce new regulations, we put a bit of a focus to that. So what you would likely see, although we haven't figured out the details of this yet, but at some point after the regulations come into full force, you'll probably see at normal routine inspection, safety officers asking about what's been put in place at a work site with regards to preventing violence and harassment. And depending on what sort of responses they get, that could lead to additional investigations.
Okay, and I think the next question is for me. How do you gauge psychological harm? So this happens in claims. We don't personally gauge it. What happens is a claim is submitted. An initial entitlement case manager will take a look at it and determine if an assessment is needed. And a psychologist or a psychiatrist would do an assessment and provide a diagnosis. There may be more questions needed to be answered. So injured workers can probably expect more questions. Yeah, and they go from the report to gauge basically if it is a claim that will be accepted or not. On to the next question. And that's me again. How do you put in a claim? So it is a very personal thing and very private. So it can be very difficult to put in a claim for harassment and violence. Be assured everything is confidential. We are very careful with that. So basically it's the same thing as a physical injury. You submit a claim, you could get the application online, and it comes into our office, and an initial entitlement case manager will take a look at it. As I said, they may contact you. to get some more answers to some questions if there's anything that needs to be sorted out. They will send you to a psychologist or a psychiatrist to get an assessment done. For psychological injuries, we have to have a diagnosis from one of those two disciplines. And the process of adjudicating the claim is the same as a physical injury. They look at all the evidence, and it's decided based on its own merits, and it's always on a case-by-case basis. Does that answer the question, folks? Do you think?
I think so.
Okay.
There's a second part to that question. When does OH&S engage with an investigation when there is a claim for psychological injury? So Yo had mentioned that psychological injury is a very personal thing. When you submit a claim, it doesn't automatically engage an OH&S investigation. That is up to the individual themselves to reach out to OH&S, and we could start that process of investigation. We would not do it without the maybe consent. Would that be the right word, Shauna? Consent or?
Yeah, it's basically that, right?
Yeah.
If someone is already feeling as though they may have been violated, we don't want to risk them feeling violated again by sharing information inside of our organization that they haven't been explicit and that they want used that way.
Exactly. Yes. What consequences could employers face if they are found not to be in compliance with the new regs? So when we engage with an employer and we're engaging with them regarding workplace violence and harassment prevention, what we're looking at is that they have a policy and procedure in place, and that it is within the parameters of the regulation. And I guess the consequence would be that they have to continue to work with us until they are, if they're found not to be in compliance with the regulation, they'll have to continue to engage with OH&S until it's found to be satisfactory and they are within the regulation.
So I see another question came in that says, the question says, I may have missed comments on this, but is there a template of what risk assessment for workplace violence and harassment available? There currently is not. We do have on our website at the moment templates for just hazard assessment in general. However, we are currently working on a similar guidance document to what was created for preparing workplaces for the new regulations. We're working on a similar guidance document that is specific to hazard assessment, and there'll be new templates in that. We don't expect a workplace to do a hazard assessment on a specific hazard. We expect the assessment to be done for the work site and all of the hazards that are present. We're putting a little bit of focus on those two topics together of violence and harassment and hazard assessment, because they are hazards that are always have been present in work sites, but we believe that it's been perhaps a bit common for some workplaces to overlook them because they're not as obvious as a tripping hazard or as an unguarded piece of equipment. And we're just trying to put some more focus there now. But that guidance document should encompass all hazards, including violence and harassment.
So I have it seems to be maybe a follow-up question to the original question that I answered about one of the staff on the Health and Safety Committee is a harasser. And the second question is, can the harasser stay on the OH&S committee, I assume, once founded of sexual harassment / assault? So I guess the answer to that is it depends. So there's two, where my mind is going is two streams. So on the Joint Occupational Health and Safety Committee, there is a terms of reference, and I'm not sure it doesn't really state in our legislation with regards to members of Joint Health and Safety Committee when they are asked to step down or removed. That is something that the workplace itself can develop in their terms of reference. But with regards to the person, once it's founded of sexual harassment, that would be captured in the procedure in regards to corrective actions, and part of that is discipline, and also part of that is training, because we'd like to hope that once it's been brought to the attention of the person that this is not acceptable behavior, that there's training provided, and there's also parameters of for all parties to understand and to follow. With regards to a sexual assault, that's criminal, and that's I mean, again, that would be something that the employer would have to determine. I mean, our regulations do talk about that workers cannot cause hazards in the workplace, so that would be.
Can I add something, Chelsea?
Yeah, absolutely. I feel like I'm rambling.
And ultimately, it's the employer's responsibility to ensure that they're providing a safe workplace to all workers. And, a lot of that goes back to what Chelsea was saying about having and following policies and procedures. But if it was found that whether it was sexual assault or really the creation of any type of hazard, someone on the Joint Health and Safety Committee was responsible for creating any type of hazard, part of the investigation and the findings and the corrective actions, before allowing them to continue in that position, they would, as Chelsea said, need to have training and whatnot. But the employers would also want to see that there's been some assurance that that behavior would not be carried on and would not cause the other workers to feel unsafe with them in that position, because that position is meant to help protect the work site, right? And provide some oversight to the health and safety management. So as Chelsea started with, it depends, but ultimately the end goal is that there's a healthy and safe work site, and everyone feels comfortable in talking to their employers and engaging in the health and safety management.
And ultimately, like, the Joint Health and Safety Committee is not meant to be a position of power for workers to be on there and to, to exercise any kind of authority in that way.
So I think the next question says, it was mentioned that an employee should disclose if there's a chance that domestic violence may be brought into the workplace. There is no way to compel people to give their employer this information. How would you suggest promoting people share this type of information? Parentheses, potential for hazard. I realize that this is the topic of this conference is on domestic violence, but there are a lot of things that are very personal to people that they may or may not feel comfortable sharing with their worksite, including things like health conditions. If someone is a diabetic, particularly if they perhaps are new to managing it, there's potential that could create problems or even hazards at the worksite. And we would hope that would be shared and disclosed with their supervisor or their employer. But it's personal and it's private, and if they don't want to, they don't have to. There isn't really an easy answer to this, other than for the employer and the supervisor to, as much as possible, develop relationships with their staff so that they are able to identify when there is unusual behavior in their workers and engage in a respectful conversation with them about what may be different in their lives at that time. And in having that open relationship, that could encourage workers to feel more comfortable bringing those very personal things to them. Do you have any other thoughts, Chelsea?
I do, thank you. Also, to have a procedure that addresses this, specifically domestic violence, and outlines that it will be kept confidential. It's who it's disclosed to and how. It has to be very clear, because it's extremely personal. we have another question. Can you give an example of how domestic violence may impact a workplace? We've seen it in the media over the years that domestic violence, the perpetrator, they want to access the victim, and if the victim is at their workplace, they will go through people to get to them. It can impact the workplace by in many ways, violent interaction.
Even just the general morale and productivity of the workplace. If people are concerned about their safety at work, then they're not able to focus on their job, which could then lead to the creation of other physical hazards, or just not producing whatever capacity they're there to do. So it's in the best interest for health and safety, but it's also in the best interest for the employer's bottom line, really, to ensure that everybody is healthy and safe at work.
And also, too, I just would like to add that sometimes people will try to keep it to themselves, and they'll try to put their own mitigations in place. And so when the employer is aware of it, they have more resources to be able to put mitigations in place, instead of trying to just, protect yourself and protect your workers or your coworkers, to disclose to the employer about the domestic violence. So we have 2 minutes left, and I'm sorry, I'm a rambler. To what extent are hazards from working from home considered workplace hazards?
Your workplace is your workplace is your workplace.
I know for us, working from home with the Workers' Compensation Board, we have a risk assessment that we do for people working from home, and we submit it to our supervisors. And yeah, like Shauna said, your workplace is your workplace. Some people work from their vehicles. What if employees do not feel comfortable to report unsafe conditions to their employers, such as reporting workplace sexual harassment? What if employees do not feel comfortable to report unsafe conditions?
I think the question is like, I think the focus of the question is about reporting to their employer specifically, maybe?
That's how I read it.
Well, with sexual harassment, generally you want to keep that as confidential and secure of information as possible, and you'd really only want to be reporting it to a narrow audience of your employer. But if you're not comfortable telling your employer, just like reporting any hazard or any incident, you could bring that to your worker representative on your Joint Health and Safety Committee. You could bring that to your supervisor. Within your reporting procedure, there should be another person identified as someone that you would bring things to if the believed to be harasser is the employer themselves. So there'd be that person as well. But if you're unfortunate enough to work in an environment where none of those are options, you can bring that to us as well. We will always want to encourage you to use your internal procedures, but if that's not an option, we're not going to leave you high and dry.
Yeah. I think there's another question here for claims.
Yeah. So how would you put in a claim if you're working from home? So it's really easy. Just go to our website, and there's a fillable form there that you can complete. And yeah, you just hit enter and it'll come to us automatically.
Great. So I guess that's it for our Q&A. If you have any other questions, or if the answers weren't clear that we provided, you can always contact us, Workers' Compensation Board, Yukon Workers' Health and Safety Compensation Board. And we would be happy to engage with you. Thank you for your time.
Thank you.
Thank you.